Today, we will have a small video on the aspect of back wages. Dear friends, any employee, when he is dismissed, removed, or otherwise terminated from service, goes to court and fights the case for sometimes years together and ultimately succeeds. And then court directs the employer to reinstate such employee with back wages. Sometimes court may refuse to grant back wages. Sometimes court may say back wages may be given but not full, that is 50%, 25%, etc. Sometimes court may direct 100% back wages. So let us understand what is the legal position on this aspect. Now, as far as legal aspect is concerned, there can be two ways. First is the statutory provisions, if at all, and the other legal position which stemmed from the judgments of the Supreme Court or High Courts, that is the common law principles and the statutory principles. First, we'll understand what is the statutory legal position. Dear friends, as far as the central government employees are concerned, there are fundamental rules. Among these fundamental rules, there is one rule, that is rule number 54. That rule deals with the inquiry and then dismissal, removal, and then reinstatement. Now, the reinstatement is concerned, there can be two circumstances wherein the order of dismissal, removal can be set aside by the court. Now, first case may be where, despite the fact that the misconduct itself has not been proven and there is no evidence supporting misconduct, and despite that the employee has been punished for misconduct which he did not do, or which at all was not proven in the inquiry, and ultimately the appellate authority itself sometimes, or the court or the tribunal, may come to conclusion that the misconduct itself was not proven. Therefore, the order is bad in law, illegal, and therefore it has to be set aside, and the employee is entitled to be reinstated with back wages. In such cases, the employee is given a honorable exoneration, that is, he is given a clean sheet. That means he is not getting benefit of any technical aspect or any technicalities. Therefore, in such cases, rule says that the employee is entitled to 100% back wages, that is full pay and allowances for the entire period during which employee was kept out of the job by way of passing such illegal order, which ultimately was set aside by the court, as I said. Now, second example, when the case doesn't fall into the first category, that means the order of removal or dismissal or termination is set aside, but not on such ground that the misconduct was not proven or there was no evidence, etc., but on the ground that the procedure laid down under the rules under which inquiry is held was not followed, or the inquiry was held in violation of principles of natural justice, or the procedural aspect, procedural irregularity, which actually amounted to gross illegality and therefore rendering the order itself illegal, suggesting that though there was a misconduct on the part of inquiry, but the employer has not followed the principle of natural justice, or the employee was not given a fair opportunity, or there was no fairness in action while punishing such employee. Under such circumstances, the rule says, Rule 54 says that the employer will have to take a decision, and in case the employer decides that the back wages would be of this quantity or that quantity. Say, for example, employer decides that the employer is not willing to pay 100% back wages, say employer says that why back wages 80% should not be given, then in such cases the employee is entitled to be heard. The proposed back wages would have to be informed to him, and he should be given an opportunity why so and so percentage of back wages be given to him, or why not to be given to him. And this also is subject to one basic rule, that in any case, even in such cases, the back wages should not be lesser than 75% of the entire back wages. So now in this second situation, back wages may vary from 75% to 100%. Employer is at liberty to decide whether it should be 75, 80, 90, 91, 99, whatever. And in such cases, the employee is entitled to be heard,